number 25, DCCR 1835. You're charged with a third-degree felony offense of unlawful possession of a firearm by a felon from October 23rd of 2025. The indictment alleges that you were previously convicted of the third-degree felony offense of unauthorized use of a motor vehicle, May 13th of 1996. Two cases of that same offense on that same date. After those were final, you were convicted of the felony of unlawful possession of a firearm by a felon, February 20th of 2007. You were also convicted on that same date of possession of a controlled substance, a third-degree felony. After those were final, the indictment shows that you were convicted of evading arrest or detention with the use of a vehicle, April 15th of 2019. And on that same date, also possession of a controlled substance, a second-degree felony, and unlawful possession of a firearm by a felon, also on that same date. What that means, sir, is that if you go to trial and you're found guilty, the range of punishment would be that of a habitual offender, which is a minimum of 25 years in prison, up to 99 years or life in prison. Do you understand?
Yes.
I have here on the tablet a plea bargain rejection that has your signature on it with Mr. Rojas that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty.
This moment is where everything is laid out in stark terms. A repeat offender, a serious firearms charge, and a history that dramatically raises the stakes. The court isn't just reviewing a single allegation, it's examining a pattern that could elevate the case into habitual offender territory. That means one decision here could determine whether the defendant faces a limited sentence or spends decades behind bars. The tension now centers on a critical choice: accept a deal or risk everything at trial.
To go forward, probably on, looks like counts 1 and 2, that would make this a second-degree felony for a 14-year term in prison. You have every right to reject that. I want to make sure you understand what the possible consequences are if you go to trial, what your options are if you wanted to enter a plea of guilty. And do you understand all of that?
Yes.
And do you want to reject that offer and have your case set for trial?
Yes.
Okay, I'll get that done. Ms. Malfino, is there any reason to believe that that offer would change? Any information you think you don't have at this point?
Judge, just to be candid with the court and not to give the defendant any false hope, I'd like to speak with the officer actually in person rather than the review of his report. There might be some question as to the validity of that search. I'll certainly bring that to the court's attention well prior to the trial docket. That would be the only reason after speaking with him that I would consider altering the offer with the court's permission. He's been before you, Judge, multiple times with 10 and 12-year sentences reasonable.
And
I
Judge,
could do that very quickly.
if you'd rather just reset a week or two.
I would I would rather if you can get that done in 2 or 3 weeks, just to do a regular reset. That way we can all say with at least some certainty that the offer is what it is based on the evidence and based on your discussions, or if something changes, then we'll take care of it one way or the other. So let's do this. I'm going to delete that plea bargain rejection for now. I'll reset it for about 3 weeks. That'll give Ms. Malfino time to speak in person with that officer, get with Mr. Rojas. He'll get with you, let you know what the final discussions come out to, and then we will see where we get at that next court date. Okay, you can go back with the bailiff.
And here it is. The defendant rejects the plea offer. That single word, no, sets the case on a path toward trial where the stakes are significantly higher. But almost immediately, the prosecution signals uncertainty about a key piece of evidence, the legality of a search. That introduces a potential shift. If the search is successfully challenged, it could significantly weaken the case. Suddenly, what seemed like a straightforward risk calculation becomes far more complex.
And Mr. Trahan is here in cause number 25 DCCR 1094, charged with unauthorized use of a vehicle. 25 DCCR 1317, charged with possession of a controlled substance, and then 25 DCCR 1536, charged with evading arrest or detention with the use of a vehicle. And we've already gone over twice now what the possible consequences are if you go to trial and what the offers are. And I see that you've signed new plea bargain rejections with your attorney, Mr. Eckhart. And did y'all go over everything, all of the discovery, what your possible consequences again, and all of that before you signed these today?
Yes, ma'am.
And obviously, the evading arrest or detention would end up being the most serious offense because it's a third-degree felony, and with your criminal history, if those convictions are true, you would be considered a habitual offender with a minimum punishment of 25 years up to life in prison. You understand?
Yes, ma'am.
And all of these plea bargain agreements or rejections are the same as before. It looks like 7-year offers in all of the cases to go on either count one, whatever adds up to 7 years, waiving those habitual enhancements. Again, you've got every right to reject these. I do want to make sure you understand that once your case goes on the trial docket, I will not accept these plea agreements after today. Your case will be expected to go to trial, or there would be some different agreement. The only way it would be this or something lower is if some new information came out that your attorney or the state's attorney doesn't know at this time. Do you understand?
Yes, ma'am.
And do you want to reject those offers and have your cases set for trial?
Yes, ma'am.
All right, we'll get them set on the trial docket, and Mr. Eckhart will begin preparation for trial. You can go back with the bailiff.
Thanks, Judge.
This hearing represents a crucial turning point in a multi-charged felony case where the defendant, Robert Trey Hand, must make a fully informed legal decision with long-term consequences. He is facing 3 separate charges: unauthorized use of a vehicle, possession of a controlled substance, and evading arrest or detention with the use of a vehicle. Among these, the evading charge carries the most serious legal weight, especially given the defendant's prior criminal history. The court makes it clear that if the prior convictions are proven, the defendant would be classified as a habitual offender. This classification significantly enhances the sentencing range, raising it to a minimum of 25 years and up to life in prison if convicted at trial. What might otherwise be a standard felony case is now transformed into one with extremely high stakes. To avoid that outcome, the prosecution has extended a plea offer that would resolve all charges with a 7-year sentence. Importantly, this offer includes a waiver of the habitual offender enhancement, meaning the defendant would avoid the dramatically increased sentencing exposure. The judge carefully confirms that the defendant and his attorney have reviewed all discovery, discussed the evidence, and fully understand both the plea offer and the risks of proceeding to trial. Another key factor emphasized by the court is finality. The judge makes it clear that this is the last opportunity to accept the current plea agreement. Once the case is placed on the trial docket, the offer will no longer be available under the same terms unless new evidence emerges that significantly changes the case. This adds a layer of urgency to the decision. When facing a guaranteed sentence versus a much larger risk, would you take the deal or go to trial? If you found this breakdown valuable, make sure to like, share your thoughts in the comments, and subscribe.